On October 3, 2025, the U.S. Supreme Court issued an emergency order in a lawsuit brought by Venezuelan TPS holders, challenging the Department of Homeland Security's decision to shorten their temporary protected status protection period. In that case, Venezuelan National TPS Alliance, a federal district court, had ruled that DHS could not lawfully cut short an already announced 18-month TPS extension for Venezuelans. DHS appealed and asked the Supreme Court to stay the district court's judgment while the appeal proceeded. The Supreme Court granted that request, allowing DHS to implement its revised earlier termination date for Venezuela during the pendency of the litigation. That was the full scope of the court's action. The case concerned Venezuela alone. No other country's TPS designation was before the court. No other portion of DHS's conduct was under review, and the stay granted applied only to the Venezuelan record and the Venezuelan plaintiffs. Yet DHS has publicly described this narrow order in sweeping terms as applying to other attempted TPS terminations, such as that for Haitians. In the case of Haitians, DHS attempted to change the end date for TPS from February 3, 2026 to September 2, 2025. A case, Haitian Evangelical Clergy Association versus Trump, was filed to block that termination, and an order entered against DHS on July 15, 2025. However, on its official TPS page for Haiti, DHS frames the case very differently. It states, Haiti's TPS designation and related benefits were slated to terminate on September 2, 2025. However, on July 15, 2025, a single judge in the U.S. District Court for the Eastern District of New York issued a final judgment. That makes the effective date of any termination no earlier than February 3, 2026. The judge did so even though the Department of Homeland Security recently prevailed in the U.S. Supreme Court, 8-1, in a similar case. The Department of Homeland Security vehemently disagrees with this ruling and is working to determine next steps. This is a mischaracterization of the Supreme Court's October 3 order, framed in a way to confuse non-lawyers as to the likelihood of similar terminations being upheld. The Supreme Court's intervention arrived dressed in the clothing of urgency, but carried far less doctrinal weight than its political aftershocks suggest. It was a procedural act executed by shadow docket and speaking to none of the issues in the Haiti termination. Yet DHS has invoked it as though it were an authoritative pronouncement on the TPS statute writ large. Today, we will examine why that leap from case-specific interim relief to generalized legal license is neither supported by the court's text nor warranted by the structure of emergency stays. At its core, the order concerns only one case, NOEM versus National TPS Alliance, a challenge to DHS's decision to cut short an 18-month Venezuela TPS extension and implement an earlier termination date. The court had been asked only one thing: whether the district court's judgment protecting Venezuelan TPS should be frozen while appeals proceed. The stay granted was narrow, explicit, and tethered tightly to the Venezuelan record. By design, it addressed no broader questions about the TPS statute and no other countries. In fact, the order highlights its own confinement. The government had not sought a stay of the district court's Haiti-related holdings, and the court declined to reach them. The boundaries were drawn on the page. The reasoning behind the stay, such as it is, rests on the court's standard calculus for emergency relief, the likelihood that the government might ultimately prevail the balance of harms and the public interest. That's not a merits determination in the conventional sense. It's a probabilistic, case-bound assessment made under compressed time and submitted without the full briefing and argument that genuine statutory interpretation really requires. Such orders are intrinsically non-transferable. They attach to the evidence presented, to the procedural posture, and to the litigants before the court. They do not announce durable legal rules, and they cannot be exported as general doctrines. Nothing in the order suggests that the court has accepted, as a matter of statutory interpretation, that DHS may unilaterally truncate a previously announced TPS extension. The majority wrote not a word about the meaning of 8 U.S.C. Section 1254, AB 3b, the provision that says a designation remains effective through the period of its most recent extension. The only justice who engaged the text, Justice Jackson, in dissent, read the statute as foreclosing midstream shortening altogether. The majority did not contradict her. It simply declined to engage with the statute at all. The silence is telling. This is not what courts do when they intend to clarify the law. What the stay does reflect, however, is a signal, a willingness by the court's majority to allow DHS's decisions to operate during litigation rather than be frozen by preliminary protection. That is a significant practical development, but it is not a legal rule. It means that in cases where DHS and TPS holders fight over an impending cutoff, the court may be inclined to keep DHS's action in force while the merits are sorted out. But again, that inclination has meaning only in the case in which it is expressed. It does not bind others. It does not settle the underlying statutory dispute. And it cannot be invoked to override separate judgments, such as the district court order requiring DHS to maintain Haitian TPS through its original end date. This distinction matters deeply for the legal system and for the immigrant communities who depend on it. Emergency stays are built for speed, not clarity. They are discretionary palliatives, not precedents. Treating them otherwise risks turning the shadow docket into a substitute for reasoned legal development, a trend that has already drawn substantial concern from scholars and practitioners alike. Conflating these stays with merits rulings reduces predictability for the public and encourages executive agencies to cite insinuation as if it were law. The central problem revealed by the Venezuela stay is not doctrinal ambiguity. It is the way DHS has chosen to weaponize that ambiguity. The agency's public messaging since the court's order has not been the product of misunderstanding or haste. DHS's lawyers know precisely what the Supreme Court said, and more importantly, what it did not say. The decision was narrow, country-specific, and explicitly limited to the record presented in the Venezuela litigation. Yet DHS has taken that thin provisional procedural order and broadcast it to immigrant communities as if it were a binding nationwide ruling that authorizes the early termination of any TPS designation it wishes. This is not sloppy analysis, it is deliberate misrepresentation. When DHS posts on the official Haiti TPS page that it recently prevailed 8-1 in a similar case, without disclosing that the Supreme Court did not stay the Haiti judgment, did not reach the Haiti claims, and did not endorse DHS's authority in any general sense, it is not informing the public. It is manipulating it. It is presenting immigrants, many of whom do not speak English, cannot pass judicial procedure, and rely on DHS for honest updates, with a false account of what the courts have actually held. This is not a legal deficiency. It is a moral one. If we are going to be honest about this moment, we must say plainly what is happening. DHS is using the veneer of Supreme Court authority to pressure vulnerable communities into believing their status is less secure than it really is, and to normalize a version of TPS policymaking that courts have not approved. For immigrants, you are being told something that is not true. The Supreme Court's order about Venezuela does not change the legal protections that apply to Haiti. Your TPS status remains in force through the date ordered by the federal court that heard your case. DHS cannot terminate your status earlier than that date unless another court changes the ruling. DHS's website is not giving you the whole picture. Your rights are not determined by what an agency posts online. They are determined by the law and by the courts that enforce it. The courts controlling your case have not authorized an early cutoff. Do not let fear based on misleading government statements push you into unsafe decisions. Consult counsel. Verify legal information. Know that the law is on firmer ground than the agency implies. The public needs to know that a federal agency is misrepresenting court rulings to the very people most dependent on accurate information. This is not a partisan statement. It is an institutional one. Whatever one thinks of immigration policy, the government's obligation to tell the truth does not disappear when the audience is immigrants. The rule of law requires not only that agencies follow court orders, but that they accurately describe what those orders say. Here, DHS is invoking the Supreme Court's shadow docket stay, in one case to imply authority in another that the court has not addressed. That corrodes public trust and distorts how our institutions are understood. If the public accepts this tactic uncritically, we normalize a government that uses legal complexity as a smokescreen, an outcome corrosive to democratic accountability. Congress, as the branch charged with overseeing federal agencies and ensuring the integrity of their public communications, must confront what DHS is doing here. This is squarely within Congress's existing oversight responsibility, to ensure that executive agencies provide accurate, non-misleading information to the public, especially when that information affects legal rights, personal safety, and immigration status. What DHS has done in the wake of the Venezuela stay is not a policy error and not an honest interpretive mistake. It is a misuse of the agency's public platform. DHS took a country-specific, procedurally narrow Supreme Court stay and presented it on an official government website as though it reflected a broad judicial endorsement of its authority to terminate other countries' TPS designations early. That framing is not merely incomplete, it is deceptive, and it is directed at communities least equipped to pass the distinction. Congress does not need to resolve the merits of TPS law to respond. It only needs to uphold a foundational democratic norm. The public has a right to truthful statements from its government, and agencies do not get to invent the impression of precedent where none exists. When DHS selectively frames court rulings in ways that materially distort their effect, it undermines the rule of law and misleads the very individuals whose legal protections depend on accurate information. Congress's role is clear. It can compel DHS to correct misleading statements, demand transparent multilingual summaries of relevant court orders, and establish expectations, through hearings or formal directives, that agencies must distinguish between binding precedent and interim procedural rulings. These are not immigration policy interventions. They are truth in government interventions. If Congress is to fulfill its oversight function, it must step in now. Not to decide who should receive TPS, but to insist that the government tell the truth about the law as it actually stands. What this episode ultimately exposes is not merely a dispute over TPS or an obscure procedural order. It is a test of whether our government can be trusted to speak honestly to the people who depend on it most. The Supreme Court issued a narrow stay in a single-country case. DHS turned it into a political instrument, aimed downward at non-English-speaking immigrants who have no realistic way to decipher what happened in court. That is not the behavior of an agency committed to public integrity. It is the behavior of an agency confident that no one will hold it to account for bending the truth when it fears the truth will inconvenience its agenda. When the government substitutes implication for accuracy or uses the opacity of the shadow docket as cover to distort the lawful rights of entire communities, It is not protecting the public. It is preying on its blind spots. And that is why this moment matters beyond TPS, beyond immigration, and beyond the narrow frame of a single litigation. A democracy requires more than lawful outcomes. It requires lawful explanations. Agencies must not be permitted to cloak unilateral power in the false authority of court decisions that never said what the agency claims they did. Immigrants deserve better. The public deserves better. Congress must demand better. If we allow executive agencies to reshape the truth until it suits their purposes, then the precedent being set is not about Venezuela or Haiti. It is about whether the United States government may mislead the people it serves without consequence. The answer to that question will define far more than the future of TPS. It will define whether honesty in government remains a principle or becomes a relic. The analysis provided today was developed by GPT 5.1 in collaboration with a licensed attorney. However, when first asked to determine the current state of Haitian TPS, OpenAI's most advanced model came back with the wrong answer, concluding on the strength of DHS's own public framing that the Haitian termination had already been upheld. Only after we dug past the agency's summary and into the underlying legal materials did the picture become clear. If that is how easily a machine built to process legal text can be steered into error by selective description, imagine what this does to a family trying to understand their fate on a phone screen in a second language. That is the real power of DHS's narrative. Not that it reflects the law, but that it can override it in the minds of the very people the law is supposed to protect.